Welcome to the deep dive. We are cutting straight through the complexity today. We're taking a huge stack of sources on immigrant entrepreneurship. I mean, everything from dry U.S. tax codes to field research from Europe. And we're giving you the crucial framework you need to understand this whole community. Our focus today is, well, it's twofold. First, we're going to map out the very specific legal structures in the United States that let immigrants work for themselves, navigating that thorny issue of work authorization. That's the structural shortcut. Second, we're going to put that strict legal world right next to the messy human reality of starting a business abroad. And for that, we're using some really eye-opening data from a study of entrepreneurs in Dublin, Ireland. The contrast is, it's striking.
It absolutely is. And it's a necessary deep dive because, we are talking about a significant economic engine here. When you look at the data from the Small Business Administration, entrepreneurship isn't some niche activity for immigrants.
Yeah.
It's a major economic pathway. Immigrants, just generally speaking, are more likely to own a business than native-born citizens.
Mm-hmm.
We're talking about 1 in 10 immigrants running their own venture. That drive, that willingness to take a huge risk by moving your entire life, it translates directly into entrepreneurial hustle.
Okay, let's unpack this. And we have to start with the foundational hurdle here in the United States, the law. For many immigrants without full permanent work authorization, traditional W-2 employment, getting hired by a company is often closed off.
Right.
And this is a direct result of the Immigration Reform and Control Act, or IRCA. It strictly mandates that employers have to use the I-9 system to verify legal status for every single employee.
That I-9 is the gatekeeper.
Mm.
So the legal pathway that allows so many people to earn a living legally, it's rooted in a critical distinction.
Which is?
Independent contracting, or IC. Self-employment. The IRS defines an IC as a self-employed person who is hired to produce a specific work result.
So the core of the contract is the result, not the process.
Yeah, precisely. Your client, the payer, controls the result of the work, but they do not control how you do it. The means, the methods, your schedule, that's all on you. You're basically running your own mini business.
And that means the client is off the hook for things like payroll taxes, benefits, and crucially, that I-9 verification.
Yes. And as the IC, you take on all the responsibility. Profit, loss, debt. It's all yours.
And this is where the legal process suddenly just opens right up. Because you are not an employee, the client is explicitly not required to get a Form I-9 for you.
That is the key regulatory finding that makes this possible for so many.
So instead of the I-9, what's the paperwork?
Instead, the independent contractor gives the client a W-9 form.
Okay.
And that W-9 is just a certification of their tax ID number. It could be an SSN or an ITIN. Then, if the client pays that contractor $600 or more in a year, the client files a 1099 form with the IRS just reporting that payment.
Which means the individual is now fully on the hook for filing and paying their own taxes. Self-employment tax, income tax, all of it.
Exactly. And this is vital. All immigrants, regardless of their status, can file and pay these taxes, whether they use an individual taxpayer identification number, an ITIN, which is available to anyone, or a Social Security number if they have one. The government wants its taxes paid.
Okay, here's where it gets really interesting, digging into the nuance around those numbers. Let's talk about the DACA scenario. DACA beneficiaries get an SSN based on their temporary work authorization. Now, what happens if that permit expires? The company that hired them before, they absolutely cannot contract with them later, right? Because federal law prohibits knowingly engaging an unauthorized individual.
That is correct. If the company knows, it's illegal. But here is the critical ambiguity our sources highlight. The SSN assigned under DACA, the actual number itself, it remains valid even after the work authorization terminates.
Wait, so hold on. The SSN is still good for tax purposes even if the work permit that granted it is gone?
Yes. And because of this, the individual may continue to use that SSN to work as an independent contractor or start a business with any other entity that is, unaware of the expired authorization.
Because work authorization isn't required for IC work in the first place.
That's the key.
Right.
The SSN is perfectly valid for filing taxes on their self-employment income.
That feels like, intentional ambiguity in the system, doesn't it?
It does.
The government issues the SSN as a tool for authorized work, but that tool remains legally viable for self-employment tax filing even when authorization lapses. It's a very narrow but, wow, a structurally sound pathway.
It's the loophole that allows resilience to function within the law. A crucial insight.
Now let's move past just being a person working for yourself and look at formal business formation. What if you want to set up an LLC?
Well, if you're a permanent resident, a green card holder, The rules are easy. They are identical to those for a U.S. citizen.
Simple enough.
The USCIS confirms green card holders have the full right to establish any business entity.
But for those without permanent residency, access to corporate structures isn't totally universal. So what's open to immigrants, regardless of status?
Most of them, actually. You have the sole proprietorship. It's the absolute easiest and cheapest way to start.
But the trade-off is huge, right?
Massive.
Yeah.
The owner is personally liable for every single business debt. It's a major risk.
Okay, so what are the safer options?
Then you have the two popular heavy hitters. The limited liability company, the LLC, and the C corporation. Immigrants can absolutely form and own both of those.
And the LLC is usually the favorite.
Highly favored. It separates the business from your personal finances, limiting liability while being pretty flexible.
But there is one crucial exception, a total non-starter, the S corporation. Why can't they form an S corp?
This is a huge point of exclusion. U.S. tax law explicitly prohibits S corp from having a non-resident alien as a shareholder.
And why does that matter so much? What are they missing out on?
It's all about tax efficiency. S corp offer that limited liability, just like an LLC or C corp. But they allow profits to be passed through directly to the owner's personal income.
So they avoid being taxed at the corporate level first.
Exactly. Without the S corp, they have to accept the greater personal liability of a sole proprietorship, or choose the less tax-efficient C corp, or stick with an LLC. They're missing one of the best tax structures available.
So their options for optimizing their tax burden while mitigating liability are just fewer.
That's the impact, yes.
Now, beyond just setting up an entity, many entrepreneurs see their business as a direct path to a green card. For those outside the U.S., what are the main pathways? It's basically prove extreme talent or extreme money, right?
That's a great way to simplify it. You have the achievement track and the investment track. On the achievement side, you have the EB1 for people with extraordinary ability or, a world-class researcher. Then there's the EB2 for those with exceptional ability or an advanced degree.
And the EB2 is really interesting for business owners because of the national interest waiver.
Yes. With the EB2, you can use that waiver to petition for yourself and your business idea, often an LLC. You're basically arguing that your venture benefits the United States so much that it waives the typical labor certification requirement.
It's like saying, the U.S. needs this person's idea more than it needs to check if an American could do the job.
Exactly.
And then there's the extreme money track, the EB5.
That's the serious capital investment route. A minimum of $1 million or $500,000 if you invest in a high unemployment or rural area. It's all about job creation.
Now, let's talk about non-immigrant entrepreneurs from treaty countries. They often go for the E2 visa. This requires a massive investment in planning, specifically a really convincing, customized business plan. They don't mess around with this, do they?
Not at all. The E2 is temporary, and it's based on two core things. First, a substantial investment. But second, and this is key, the business cannot be marginal.
What does not marginal really mean here?
It means the business has to show it can do more than just generate enough income to support the investor and their immediate family.
It has to have growth potential.
Right. Viability, clear economic contribution. Your business plan is your core evidence. It needs 5-year profitability forecasts, expansion strategies, and potential for job creation.
And the sources all emphasize that the big pitfall here is using a template. A generic plan is a huge red flag.
It almost guarantees denial, because a generic template shows zero due diligence. The USCIS adjudicators are looking for evidence that you've thoroughly researched the specific local market, the competition, that you have a unique value proposition.
So customization is everything. It proves your long-term success isn't just a hopeful dream.
It's the only way.
That structural overview gives us the blueprint for the U.S. system. But does having the correct paperwork actually fix the fundamental, on-the-ground problems of starting a business?
That is the perfect transition. Because if we zoom out and look at the qualitative findings, the answer is often no. Let's look at this study of immigrant entrepreneurs in Dublin. It strips away the specific U.S. laws and shows us what the universal hurdles, financial, social, emotional, really look like.
Right. And one of the first findings from this study, which included entrepreneurs from Nigeria, Brazil, Ukraine, was actually a surprise about language.
Yes. Language acquisition, often cited as this top obstacle, really wasn't a major hurdle for this group. All of them were proficient in English and saw mastering the language as just, non-negotiable for success. The language barrier was conquered.
But the financial barrier was profound, and it speaks to a deep lack of trust in mainstream institutions. Tell us about the loan situation.
It was startling. Zero participants initially sought funding from traditional banks.
Zero.
Zero. They skipped the formal economy altogether. This was driven by a deep-seated fear of rejection or a perception that the system was biased against them. They relied exclusively on personal savings and informal loans from, co-ethnics or family.
And we see why that fear might be justified. There was that example of the Nigerian entrepreneur who was seeking expansion funding.
Right. He was rejected. The reason given was insufficient credit history and lack of collateral. But he was convinced his ethnicity played a role. And our sources confirm this is consistent with broader research. Immigrant-owned firms just face far more significant financial obstacles.
Okay, so here's the paradox. They didn't trust the financial institutions, but they did trust the legal framework to a degree.
Yes. The interviewees unanimously agreed that the process of actually starting a business in Ireland was easier and less corrupt than in their home countries like Brazil or Ukraine.
So they see the government regulatory structure as cleaner, more trustworthy.
Exactly. Less bureaucratic than the chaos they left behind. Yet, and this is the key thing, despite this positive view of the law, the study found a widespread lack of awareness or use of crucial government support systems, things like Enterprise Ireland.
So why is that? If the system is cleaner, why are they relying on Google searches for legal info instead of engaging with the agencies designed to help them?
It suggests this profound level of distrust, but it's about active support and advocacy. They're willing to follow the law because it's less corrupt, but they're clearly fearful that engaging with government support will just expose them to bias or be a waste of time.
So they choose self-reliance instead.
Self-reliance and the certainty of their own ethnic networks over the uncertainty of the mainstream system.
And that reliance on their own networks, while it provides that crucial initial support, then becomes its own barrier to scaling up.
A huge pain point. One Brazilian entrepreneur, for example, imported specialized bakery equipment. He needed to connect with firms back in Brazil because he felt the local Dublin business network was, in his words, mentally closed.
Unwilling to share knowledge or adapt to his new ideas.
Exactly. So this self-isolation, which was born of necessity, then stunts his expansion into the broader host economy.
And even just managing the workforce became this regulatory headache that hit their bottom line.
Absolutely. So some businesses naturally had to hire co-ethnics. The Brazilian bakery needed Portuguese speakers. But the complication came from student visa limits. Those limits capped work hours at 20 per week. So this forced one business to hire way more staff than was technically needed just to cover all the shifts.
That's a massive inefficiency.
It is. It dramatically increased employer costs, specifically the social insurance tax, BRSI. The legal rules meant they were paying considerably more just to operate.
And finally, we can't talk about the reality of this without addressing the raw finding of discrimination and bias that was reported so frequently.
The study was stark on this point. Frequent incidents of explicit bias. 3 shop proprietors detailed these recurring, painful incidents of racism being told to go back to your own country, especially when they confronted shoplifters.
And it wasn't just verbal abuse.
No. It was coupled with a perceived failure by local law enforcement, the Guardia Síochána, to provide adequate protection in the inner-city areas where these businesses were.
And it wasn't just on the street. It affected fundamental business assets like leases.
Yes. A Ukrainian entrepreneur suspected that his landlord's decision to refuse his lease renewal and instead allow an adjacent Irish business to expand into his space. He felt it was a case of what he called Irishmen facilitating Irishmen.
Wow.
It suggests that even after you master the forms, you generate profit, you comply with all the regulations, your nationality can still factor into these crucial local business dealings and just derail your whole operation.
So what does this all mean? Our deep dive reveals this really complex duality. The U.S. offers these incredibly structured, if complicated, legal pathways. The IC designation, the LLCs, the structure is there.
But the global reality, which we see in the Dublin study, shows that immigrant entrepreneurship is fundamentally an act of intense personal resilience. They're forced to build their enterprises almost entirely on personal capital, financial, social, emotional, precisely because they encounter this lack of trust and access in mainstream systems.
It confirms that the kind of people who choose the challenging road of emigration are already hyper-entrepreneurial. They're risk-takers. They're proactive.
And they have the self-assurance necessary to start from the margins and succeed despite these incredible barriers.
The discussion about the difficulties they face so often focuses on, finance and language.
Right.
both of which these individuals often solve themselves through sheer will or their own resources.
But the sources point to a much deeper, more foundational challenge that host nations have to confront. How can these nations move past what the study calls the master narrative of racism and distrust to truly foster these resilient entrepreneurs?
Because their contributions are currently being held back not by a lack of drive or an inability to fill out the right W-9 form, but by the perception of their othering. That is the real policy challenge.